So I wanted to go over the Bryan Kohberger January 23rd hearing for the Franks motion, explain what that is, and everything that was said in the hearing on the 23rd. This is going to be a probably multi-part series because it's a lot. I got through the 23rd hearing and I want to summarize that for you, and then I still have to get through the 24th. I'm pretty detailed with my notes, so bear with me. So this is going to be my part one of explaining and starting. So what is a Franks motion? Okay, a Franks hearing is a court proceeding that determines if a police officer's affidavit for a search warrant contained false or misleading information. The hearing is named after the 1978 Supreme Court case Franks versus Delaware, which established the legal standard for challenging search warrants. When is a Franks hearing held? A defendant may request a Franks hearing if they believe the officer included a false statement in the affidavit. So Anne will go on to explain multiple reasons why she feels false things were included in the affidavit that got the search warrant and was presented to the judge to get such thing. The defendant must show the false statement was material, meaning it was necessary for the magistrate or the judge to find probable cause. Well, what happens during a Franks hearing? The defendant challenges the affidavit's statements or omissions using evidence like witness testimony or documents. The judge decides if the defendant has made a sufficient showing to grant a hearing. But why is a Franks hearing important? A Franks hearing protects citizens from unreasonable search and seizures, i.e. the Fourth Amendment, which are prohibited by the Fourth Amendment. That's what I had in my notes. Franks hearings can be a powerful tool for defendants, especially if evidence was obtained during an illegal search. So that's what her whole argument is, that there wasn't warrants at different stages of the IGG search, and therefore it was illegally done. So now that we know what a Franks hearing is, why it's held, and what they're hopefully going to obtain from it and get it granted, let's start going into what happened at the hearing. So the first part of it was closed, I believed, and now we're going into what is not closed. By the way, the closed part is going to be given to us in a text format. If within 14 days they do not give him anything to redact, the judge is going to make it public. And that came out after the hearing. The judge was saying he's going to do that. So the first thing brought up was the suppression of the IGG. IGG is investigative genetic genealogy, which is the DNA that linked Bryan Kohberger to the sheath that was found at the scene under Maddie Mogen. We still don't know how they got to Bryan Kohberger, other than there was a tip given to the FBI. The FBI gave it to Moscow PD, and then through investigative genetic genealogy, he was linked to Bryan. We do know that there was 3 searches that were done that are being presented as being done illegally, and I will get into that. So Anne presented that at 3 there was no warrant for several stages of the IGG in 3 different points, right? The first one being the ISP, or the Idaho State Police Forensic Lab, moved a DNA sample from Altern Lab to IGG for IGG SNP. And what is an SNP profile? Let me explain that. An SNP profile, SNP, S as in Sam, N as in Nancy, P as in Paul. SNP profile is a genetic profile that identifies a person's single nucleotide polymorphisms, or SNPs. Okay, SNPs are the most common type of genetic variation in humans, occurring in most every person's DNA. Okay, the second time that a warrant was not found was when it was transferred to the FBI. And the third was the trash pull in Pennsylvania outside of Bryan Kohberger's home. She also argues that the Fourth Amendment, Article 1, Section 7 of the Idaho Constitution, the society is not ready to support suppression, privacy of every bit of DNA. So she's saying, what is society going to agree that should be suppressed? And that's what we haven't agreed to as a whole, as a society yet, because this technology is so new that I don't even think we have guidelines of how we're going to be using it in cases going forward. That's why a lot of it is inadmissible, meaning it cannot be presented at trial. Think of it as like a lie detector test, right? People can do it and it can be a part of the evidence, but usually it's not presented at trial because it's so unreliable. The judge said to Anne, "Do you have any cases that support this?" And she said, "No, but I also don't have any to the contrary as well." I have in my notes, what the FBI and Moscow PD did has been in secret and should concern everyone. Lots of things that were done to ID Bryan Kohberger, but never explained how. Search didn't lead anywhere at the state level, and then when it was given to the FBI and they took over, they have no idea what they did. Nothing was documented, and being able to be replicated to confirm what they did was legitimate. Altered lab procedures were given to the defense the day of the hearing on January 23rd. They've been asking for this information. They had not gotten it previously, so therefore they had no chance to review it, and that's what she told the judge. She goes on to explain that the S&P profile that we just discussed went from being twice as small at the state level, and when they transferred to the FBI, all of a sudden it grew 2 times in size. And you kind of have to wonder and question, how did that happen? What was introduced and included from the state to the FBI? And the defense says they don't know how that happened and what exactly changed it to being 2 times the size and big, and 2 times in the size. The judge turned around and asked Anne if she was asserting privacy when it wasn't his DNA searched in the database, it was his ancestors. He's asking if, like, for example, he started giving an example, like, if a relative knowingly gives DNA to a database, that he himself, he's talking like him as the judge, should be able to stop it since they share DNA. So if someone else gives their DNA to a database, but you share that DNA, can you stop that from being given because it violates your own privacy? And that's what he's trying to say is a little tricky and not a really solid argument. Where I find issue with that is Bryan's dad, his DNA was on the trash that was pulled in Pennsylvania. He did not give his DNA willingly. It was taken from a piece of trash outside of his home. So he did not give his DNA to this database, or did he? I mean, they haven't explained if his information or Bryan himself gave his DNA voluntarily, because as of right now, neither of them did. And then work not done lawfully. Also, it was found on a movable item, which I want to point out, on a knife sheath, that it could be planted at a scene. So it's not a stationary item within the crime scene. So that would be something I would have pointed out to the judge, because he makes a big deal about, oh, well, it's found at the scene, so therefore how could he have any kind of rights to privacy? But it's like, wait a minute, it's on a movable item that could have been placed there, not something like, for example, when they found the blood on the railing, that is a stationary place in the home. It's not something that could have been moved there and left there by someone else. They talk about a Ross case and saying it was intentionally leaving of something. I'm not really sure what they were trying to get at with that. But privacy issues, not just a name. So when she's talking about there's privacy issues with the DNA, it's because when you get an S&P profile, it's your entire genome, which means that it's not just the name you're getting of the individual, but it's getting all their medical history, what their ailments are, what they could be predisposed to when it comes to things that diseases that they could get later in life, things like that. And so it goes into like the whole HIPAA aspect of it. Is there privacy expected when you're checking someone's DNA, especially if they're not the ones submitting the DNA, but they're related to people who maybe have, or they haven't submitted their DNA at all? Should they have a aspect of privacy? And the judge is saying, well, if his DNA is at the scene, how could he expect privacy if his DNA is at the scene? But it's on a movable item. It's not stationary. Yes, it was there next to the victim, but we could argue that someone left it there or put it there. So I'm getting down to my last minute of being able to record, so this is part 1, but I do want to make the next point. Davis, they talk about a Davis case, subsequent searches, that they needed a warrant in that case. She says 690 F3rd 226 is what she quotes. There was a note about a closed hearing, 2 databases not allowed to. And then they go into how the Department of Justice, or DOJ, their own policy for the FBI is to not go into those databases, recognize expectation of policy in searches of privacy. So the own FBI has their own policy within the DOJ to not search databases that they're not allowed to. And they're believing that they did in this case. So that's my end of part 1. If you'd like to see more, make sure you hit that follow and subscribe button, and follow me on YouTube as well, because I will stitch all of these together and place them on YouTube. But I hope that makes a little bit more sense, and I will go into this a lot further because I have a lot more notes. But thanks for watching. Hi everybody, so this is my part 2 of the hearing overview for January 23rd for Bryan Kohberger versus the state of Idaho in the Idaho murders. We have been reviewing the very beginning. If you have not seen it, please go look at my part 1 on my profile. Now let's get into part 2. Where we left off, we were talking about the DOJ and how they have certain databases that they cannot search, and it's an internal policy that they have. And the defense is alleging that they did search these databases, even though they're not supposed to, for Bryan Kohberger. So the question was posed, was Bryan Kohberger in any of those databases? And Anne didn't answer. She said warrant was required to search all of that. The DNA left at a crime scene has any expectation of privacy? That's what the judge asked her. Does the DNA left at a crime scene have any expectation of privacy? Anne said we all leave DNA everywhere all the time, i.e. shedding, right? And that will be the subject of the trial. So Hippler was kind of baiting her at that point to try to make her argument that she essentially would make at trial, and she didn't fall for it. This isn't like, she explained that this isn't like fingerprints or blood or seminal fluids, things like that. It is touch DNA, and that can be picked up from anywhere. And that the tests that were done on this DNA were going to give more information than just a name. It's going to give a lot more details about the individual. And that's what they're contesting about privacy issues and consent and Fourth Amendment search and seizure illegally being done. Now, she indicated that learning that day, they're starting to learn how they got to Bryan Kohberger in open court on that day, and up until this point they didn't have an idea of how they got to him in a legal way. So Anne finished, and now it's the state. They were up. The judge says to the state, why should I permit evidence searching databases that by its own policy said it wouldn't search? And I found that very interesting, because if he's asking a question like that, he obviously sees that there's something wrong. And the state said there's no violations of terms of service, millions sharing with databases willingly, but did Bryan Kohberger do this? They didn't answer. The judge said, isn't there a subset that doesn't agree to this? Meaning, like, aren't there people who check a box on all these different DNA websites or genetic websites and saying, I don't want law enforcement to be able to use my DNA in their databases? FBI usually agrees to not search those, right, with their internal policy. Is there a difference between sharing with the company and lawfully obtaining and going through a back window and taking it? So I found that very telling, that the judge obviously is conflicted and he sees something wrong and he wants them to explain this. Now, the state's response was saying he's not a customer of one of those databases. And they quoted interim policy of DOJ, but keyword used in their statement was lawful. And this was at 29 minutes and 22 seconds on my video. The whole hearing is posted on my channel on YouTube, Blahgergirl. If you guys want to watch it, it's over 3 hours. I'm just trying to summarize it for you and make a little bit more sense of it in layman terms as much as I possibly can. But if you do want to watch it, it's at the moment of 29 minutes 22 seconds that he makes this argument. Now, what I find funny about that is he uses the word lawful, and that's the whole point of this, is saying, did they lawfully get it, not illegally, you know? So also, if Bryan, they're arguing that if Bryan wasn't a customer of one of these databases, he doesn't have a right to privacy because he doesn't fall underneath the privacy standards of the company because he's not using their services. But that's even more reason you could argue the opposite way, that if he's not a part of their database and their privacy policy, he still has the Fourth Amendment at his disposal, which means unlawfully searching and seizing. The state basically argued, saying that the policies do not equal the Fourth Amendment violations. Supreme Court want to know what he's quoting when he's saying that. So he quoted a Supreme Court case, but didn't state what it was when he made that statement. He said best practices, not law, but not law. Why wouldn't you? And I was thinking to myself, why wouldn't you want to follow best practices for a company in general? Defense leaving out where the DNA was found at a murder scene. So the defense was saying they're not pointing out where the DNA was found. They're just trying to figure out how they got to Bryan and was it legally done. But they don't point out that it was found at a murder scene. But again, that brings me to the point that the knife sheath was movable. It could have been planted. So what else do you have on him? We need to know that. The prosecution talked about the Davis case and touched upon what the defense had entered into the hearing and said the investigation was into a shooting. The officer went into a hospital victim's room. A bag of clothing was in plain sight, and the view exception to warrant requirement, because it was in plain sight, well, then later the victim becomes a suspect and they test it later on, which the Supreme Court at the Fourth Circuit says, no, you can't do that. So then he goes on to make the argument that no search warrant required for crime scene DNA, and that no case where DNA analysis states reasonable expectation of privacy. He also touched upon the Supreme Court of Arizona, saying that DNA collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood. And then they said the Davis case, no privacy lost, DNA consented to be tested, blood not found at a crime scene. Idaho appellate courts addressed this. So the prosecution went on to talk about the analysis didn't reveal medical information. They talked about how the defense's expert even said that he's developed hundreds of S&P profiles and never once released medical information about any of those individuals. Prosecution went on to say that they did nothing to obtain medical information about Bryan Kohberger, but that inherently comes from the DNA profile. He said defense is arguing what could law enforcement do with the DNA profile. He asserts what did they do? Exactly, counselor, what did they do with it? That's the whole point. He states a case, Maryland versus King, and addresses that there was no problem as long as the law enforcement limits the identification of the DNA profile to just identifying somebody and not anything else. But in this case, we still have that question unanswered. Did they? The prosecution was saying that Bryan Kohberger is trying to have the best of both worlds, that he wants to deny it's his DNA, but also claim Fourth Amendment standing to privacy, and they are saying he can't have both. They talked about the trash pool in Pennsylvania, cites Donato and Paluzzi, says it's very recent and arguments were rejected. Defense is saying this is different because it is not clear where the garbage cans were located and that maybe the officers went up onto the driveway instead of collecting them from the street. And my question would be, how do you not know definitively which way it is by now? The judge did correct them at this point and said that the trash company collected it for the officers prearranged with the FBI. Says defense didn't provide documents that weren't clear. Says defense didn't provide documents that weren't clear. States that FBI included video showcasing a body cam and it shows the trash cans at the end of the driveway where they should be before trash is collected. State conceded that there isn't a lot of information because they aren't planning to use the IGG at trial. But the point is they used it to get Bryan Kohberger and link him, and it's been secretive of how they did this. This was the final part of the prosecution being up at this point, and it said the judge asked if the FBI did violate the Fourth Amendment for Bryan Kohberger. He asked if they would agree that the state is then burdened by that, and he said yes, they would be. So he's kind of caught people. He does it to Jennings, he does it to the other counsel for the state, and he catches them at moments where they have to concede to what he's asking and agree with him, and I don't think they like that. But he also does it to Ann too, so he seems pretty fair. He just asks really difficult questions. So I'm going to stop there because then we're going to move into Taylor coming back up to the podium, and she's going to kind of rebut what the prosecution just said. If you like this, make sure you hit that like button and follow and all that good stuff. I'm going to be doing multiple parts for this hearing because it was quite long and try to address everything that I can. If you're interested, make sure you follow me on YouTube as well, Blahgergirl, Blahgergirl, and follow on there because I will stitch all of these together in one video if you prefer to watch things on that platform and that media mode. So make sure you hit that like and follow button. I will be back with part 3. Hi everybody, so this is part 3 of my review of the January 23rd hearing for Bryan Kohberger versus the state of Idaho. Where we left off, prosecution had come up and said their piece. If you haven't seen parts 1 and 2, make sure you go hit my profile and take a look at those before listening to this video. In this part, this is where we're starting as Ann's coming back up to rebut what the prosecution has stated so far. So, Taylor. So this is her talking. The state is burdened by what the FBI did and that they didn't want anyone to know what they were doing. She points out she received 3 new things in this hearing alone, yet the state is claiming they are complying with every request, which clearly they aren't. The judge comes in and says, Supreme Court ruled that you lose all expectation of privacy once you put your trash on the public street, so how does, no matter if the neighborhood has ordinances, change the analysis? Taylor says it's different when the FBI is telling the trash men to go grab the trash and bring to them. DOJ says not to check databases that they are not allowed to check into the lead and how specific it was. How did they get to that? But the FBI violated its own policy. She goes to talk about the SMP profile, or they call it SNP profile also. She explains that it's a whole genome. Potential is there. For $12, you can upload a profile and find out more information. So Carpenter addressed this. There's a privacy interest in health matters. HIPAA applies here. How is that not a Fourth Amendment issue? And it was done 2 times without a warrant. So now we're going into the Frank's argument on IGG and proffer. The PCAs had, and they said PCAs as like in multiple, and we've only seen one from Payne, right? So I want to see the other ones that they're talking about. PCAs has had false information that was intentionally placed, intentional omission, and exculpatory to Bryan Kohberger. 13 areas to discuss. IGG not in preliminary stage. December 23rd, search warrants is what she's referring to. A few days prior to Bryan Kohberger's name came up in investigation. You wouldn't know that by the PCA. Information is omitted. She again states that the FBI violated its own policy. No records. That was the only way the name was produced. Lead detective never heard of Bryan Kohberger prior. They searched databases they shouldn't. No records or processes to replicate. And judge never knew this. The judge may have changed her mind. She talks about the PCA is a group effort. It says affidavits as in plural, yet we've only seen one. The FBI they were co-located with the Moscow PD. They were basically in the same room during the investigation. So she's pointing that out. First warrant is AT&T, 48 hours of records. IGG withheld from judge. PCA talks about an interview they had heard and saw things within her house, meaning Dylanmortensen, wrong and false and lacking in detail in PCA. Speaking about Dylanmortensen, she thought she heard as an issue. The person was interviewed after 911 was called on November 13, 2022. She talks about Defendant's Exhibit 8A as an apple, victim going down and upstairs and not mentioned in PCA. So she talked about one of the victims going up and down the stairs and later says we obviously know that's not true because she was found in the bed, deceased. So, and that was not mentioned in the PCA. Page 287, subsequent interview of defendant 8E8B, page 313, 320, D8C 96, page 398 and 403. Important and is misleading to the judge. The officers knew that wasn't the case because that person was killed in the bed and not possible. They don't tell the judge that. Witness claimed memory problems, not sure what she heard of or if it was a dream, stated she had too much to drink and couldn't remember. And that was all new information the day of that hearing. We had not heard anything more really about Dylanmortensen other than what was put in the PCA, but now there was a little bit more detail given. She was talking about in the PCA, vehicle number 1 trails of path of cameras. The camera near the 1122, you can't tell what kind of car it is. Expert couldn't tell, pieced together from various videos and area, but they don't tell the judge that. Year of vehicle was also in contention. Law enforcement worked with the FBI to determine year of car, provides probabilities. D9 is what she refers to. After several submissions, FBI could identify 2011 to 2013 at first. D12 Bolo, or be on the lookout. They don't tell the judge that's what they are looking for, and that they have this car making a loop, which it isn't. So basically what they're telling the judge about the car, it was a bunch of cameras all over the place, stitched together to make it look like one car is driving around, and she's saying that they've found discrepancies in that, and she gets into it a little bit later in more detail, but she's saying that the judge wasn't made aware of that, and that if she had, she might have made a different decision, and that the changing of the year of the car to match Bryan Kohberger's car is an issue. She also mentioned the dog Murphy, Kaylee's dog, was barking, and something happening inside house. Use the time on camera. Dog keeps barking long after the car leaves the area. There's no blood on the dog. It's found in a room later. Judge not informed of this. There was traffic stops with Bryan included to bolster investigation when they don't have anything to do with it unless IGD involved. So she's basically saying the traffic stops that we've seen were included as evidence for the warrant, but they have nothing to do with this particular situation, and they will only be connecting him through IGD with regards to those traffic stops, because they absolutely have nothing to do with this. She states Bryan Kohberger's car is 2015, placed as an investigative fact, but it was just a call returned to WSU. Judge not being told all these details could have changed mind. Judge, if finds IGG was not unconstitutional, would it bolster the PCA? Taylor, now look how that would look. Okay, sorry, I'm trying to read my notes and understand, but basically the judge is trying to ask about the PCA and how the IG would affect that if it was found unconstitutional, or if it's not found unconstitutional as a whole. Taylor says, no, but look how that would look. We did not keep any documentation, even though DOJ says we have to. Can't go into the databases, but we do anyway. You're looking at integrity and what a judge can look at to give a warrant. So she's basically saying they did all things backwards. They don't have anything recorded, but yet they were granted a warrant based on what? That's the question. And if more details were given, would the judge have made a different decision? The judge goes on to try to I make sense of the reason that they're referring to the 2 traffic stops for Bryan Kohberger, and he was thinking it was to identify the car and that it had no license plate, especially on the front, because Pennsylvania doesn't require a license plate, and the suspect vehicle 1 didn't have one either. Taylor addressed this and said the license plate is not something you can see from the videos. No videos obtained from WSU, no communication with the officers at WSU before the identification through IGG. So she's basically saying you can't see anything in the videos anyway, and the communication that you had with WSU only happened after the IGG stuff was processed. The judge is trying to say, I'm not tracking why this matters. And Taylor goes, it's not a real investigation. Don't look how we identify him, but warrant issued. She talks about the second warrant. The first one came in, and an hour later, all this data was analyzed and it needs 6 months worth of records for the second warrant. Phone not within geofence. In the first warrant, the PCA talks about 2:42 a.m. WSU cameras. Find a white car that is an Elantra at 2:42, then it becomes 2:44 leaving his residence. Time discrepancy, but don't correct that. The cars at 2:42 could not have been the correct car. They know that it's 2:44 a.m., but they keep that in there because that's what they want to appear like the car is going to Moscow. This misleads the magistrate. Looking at map 1A in the PCA, blue line towards Moscow, the phone stops reporting at 2:47, and that's not right. It stops recording at 2:54 a.m. Call detail records show ground that can be covered in that 7 minutes is a big deal and not corrected in any PCA. Exculpatory what direction he is traveling when it stops reporting. FBA chose not to correct. So that's where I'm at for part 3 of the overview for the hearing for January 23rd. I'm going to stop here. Make sure you give a like and a follow, and definitely follow me on YouTube as well, because I'll stitch all of these together at the end when I'm done recording. But part 4 coming soon. So this is part 4 of my overview for the Bryan Kohberger hearing that happened on January 23rd. We are basically at the part where Taylor is saying that there was a 7-minute discrepancy with the time of Bryan's car versus the white car that they're trying to stitch all the film together and say that that's his, and that his phone didn't stop recording until 2:54, and so that information would be exculpatory to him, but that the FBI didn't correct that in the information given for the PCA, the warrant, to the judge. Now Taylor is talking about D7 and D8, defense experts affidavits and CVs in D8 28. Warrants for Bryan Kohberger comes afterwards. Paragraph talks about the phone using 1122 tower 12 times. D1B and C, email from Nicholas Balance. He's the FBI person in the case that did the cell phone analysis. Talking to Moscow about dates this happens, and they don't match up in the system, and so it's misleading to the judge. She says that they knew that Bryan Kohberger was not around that residence. didn't stop in stationary position, but the law enforcement put it in the PCA so that the judge would think that this is the right person. Drive testing also came in, which proved that this isn't true. And Dylan interviewed many times and says different things, false narrative that looks like stalking. And she's referring to when they're talking about he was around the residence 12 times before the murders. It gives the impression that he's stalking the victims. And that's just not simply the case in her argument. February, March, and April warrants for Amazon, Google, etc. What's left out of those warrants is the car, residence, etc. All get searched and no connection, no blood. So she's saying they got all these warrants in February, March, and April for all these other things like Amazon, Google, etc., and that there was nothing found with regards to any connection to the victims. There was no blood in any of his residence, his office, his car, his parents' home, nothing that links him to these kids. She had moved on to the warrants after the arrest, and the judge asked her at the time of the arrest they had a direct DNA connection, even if disclosed, preclude a finding of probable cause when there is a DNA match between the sheath and Mr. Kohberger. Isn't that probable cause every day, twice on Sunday? So he's saying if there's DNA at the scene, isn't that enough probable cause for the judge to sign a warrant? Taylor's like, not in this context because of the IgG work. She seemed a little stumped when he asked her that question. Like I think she struggles a little bit more in front of him than she did in front of Judge in Moscow, because she's probably used to being in, they kind of seem like high school people, all of them there, just the way that they presented and acted. And Hippler, it's like, you're the big boy field now, and you have to really prove your case. You can't just say whatever you want to say and think it's going to fly in his court. She went on to say that that's what the jury will have to decide. What does the knife sheath mean? He retorts, I would think it probably means a lot, which I don't know why he's inserting his opinion, because that's not what this is for, which he's already asserting an opinion for the jury that the knife sheath is not nailed down. It's a movable item. I wish she had pointed this out at that point, because it could come from anywhere. It could have been planted, and she didn't say that at that moment. She does say it later, but she didn't in that moment. I'm like, I wish she had just said that, because it would have stopped him in his tracks. Judge was arguing probable cause is not the same as proof beyond a reasonable doubt. He was not sure how the lack of evidence elsewhere affects the evidence found at the scene. The judge wasn't made aware that there was no evidence elsewhere. That one piece they do have is not bolted down in the room, and someone could have placed it there to frame Bryan Kohberger. There's your reasonable doubt. The judge was not afforded. So that was my take on it. Like, I wish he had kind of said that, but no blood anywhere in his vehicle. Judge mentions multiple affidavits, but we've only seen one. Unknown male B on a handrail. Fines says you could carry that sheet to the house. Car being empty of evidence. Judge addresses handrail DNA. Does that not exclude Bryan Kohberger, but suggest another person was involved, or could have been another instance unrelated to the house? This is exactly why the magistrate needed to know and wasn't given a chance to ask, because she was only told the details, even the glove on the DNA outside the residence, nothing in car, and only 13 minutes to commit this crime. It just doesn't seem plausible. And she wasn't kind of given all that information at the time of obtaining the warrant. The judge really seemed like he was stuck on that knife sheath, and she asked, it's the question of how did that get there? And I'm like, thank you, finally, she said it. DNA on an object at a scene, because there are other factors, and with all those factors being told, that one fact may not seem so big. And that was the end of the proffer argument for Frank's hearing. So then Ashley Jennings gets up, and this woman, I can't. She has such an arrogance about her. Like, it makes you kind of physically ill to watch. She is so arrogant. And when you watch it, you'll see if you end up watching it. It's on my channel, on my YouTube channel, Blahgergirl. But anyway, so let's get into it. Ashley Jennings. There's two separate inquiries for each of the claims that they've brought before you. Has the defendant made a substantial showing that the affidavits were the basis for the warrant applications? Omissions. And second question, does that even matter and diminish the probable cause finding? Yet to those questions, you would grant a Frank's hearing. Law enforcement lied to magistrate to get the warrant, had to be deliberate in false statements. Says this is very shit. Well, no shit, Sherlock. It's fucking serious. Of course it is. Why she says this stuff, I don't understand that. 13 areas that she's going to touch upon, because the defense touched upon 13 areas. Exhibit A, law enforcement's statement. So Exhibit A on the PCA is all their statements. Facts known to them to get the search warrant. Exhibit was 20 pages at the time, relied upon for different warrants. Detective Payne testified during the closed hearing that day, 2 briefings a day that were given. So they gave 2 briefings as the police, they did that. Info was put in there for the search warrant. So they included that. Judge, what do I do if exhibit is attached to Detective A's affidavit? And there's a purpose for my question. He says a matter of reckless statement in there. But Detective A, so he's saying, but let me read it. But Detective A is not the one who made he's basically saying Detective A is Payne, and he's writing this PCA. But then you have this Nick Balance, making statements that may have not been done properly or potentially false. How does that affect the PCA as a whole that Payne is writing if parts of it are not being valid, right? So like if Dylan is saying all these statements and she constantly keeps saying different things, she's been interviewed 5 times and each time it seems different or it's wishy-washy or whatever, you can't count on that, right? Then you have Nick Balance coming in from the FBI doing this analysis, and did he do it lawfully? If you can't count on that either, how does that affect the PCA or the document that Payne wrote to get this warrant? How does it affect it as a whole if you take those parts out? Because if they're not included for trial, what do they really have to stand on? So the judge was asking, how does that affect the Frank's analysis with regards to Detective A, meaning Payne? It was a group effort and statement, and it made its way ultimately to the magistrate. She conceded that there was an issue there, but quickly stated, but that's not what happened. That's exactly how she said it too. Group effort, just because she says it doesn't happen, you need to have proof that that didn't happen. And I still haven't seen that from them, and that really bothers me. You can't just say statements. It's like they have this high standing for the defense to do that. You can't just make statements, oh, he wasn't there, this, whatever. They have to prove that he wasn't there, just like you have to prove that he was. It goes both ways. In this instance, you have to prove that your deputies or your FBI members did not make false statements or do things illegally. She went on to say group effort is allowed, several Idaho cases that support this, Rubio, Gomez, etc. The judge was put on notice. Each affidavit stated that other agents were helping Moscow PD. Issue with who did the work with reference to Google, Blahgergirl, Exhibit A. So I have a problem with this Blahgergirl. Blahgergirl's the one, if you watch my series that we're going back to the beginning, he was the one that was bragging about drinking when he was younger and throwing the alcohol out during that one visit to the house. And if you watch him, you'll see what I'm talking about. And I told you it gave me vibes that he was like, hasn't left high school. He's involved in this, but he's also involved in the raid on Bryan Kohberger's apartment. And I just feel like it's so interconnected. There's something there. I don't trust that officer. She's saying it's inaccurate because Blahgergirl did not claim to do the cast work. Judge clarified AT&T records, and she says they didn't take those records and put them into cast software, Balanced it. So Blahgergirl used cast work to determine where the phone was and made determinations for the 8458 phone, which is Bryan's phone. So I'm going to stop that. That's part 4. Part 5 is coming soon. Sorry for so many parts, but I only have 10 minutes per section on here. So if you want to see this in its entirety, I'm going to put it on my YouTube channel, Blahgergirl. So thanks for watching. Make sure you hit that like button, follow, and leave a comment if you have any questions or want to add anything. And thanks for watching, and part 5 coming soon. So this is part 5, I believe, of the hearing overview for January 23rd for Bryan Kohberger versus the state of Idaho for the Idahofour Moscow killings. If you're interested in hearing more about this, stay tuned because I'm about to tell you more. If you have not watched my previous 4 sections or parts, make sure you go to my profile and watch those first. If you'd like to watch everything together, I will be stitching it all together in a YouTube video shortly and putting it on my YouTube channel. Where we left off is they were talking about this officer Blahgergirl and how he relied on the information that this Nicholas Balance from the FBI, who did the overview and analysis of Bryan's phone, to put it into the PCA. So she's talking about the records for the phone, 2 different opinions, 3 towers in Moscow area. The judge here is, and then he stops her because this is the first time that they've said 3 towers service the Moscow area, and he's concerned if you're inserting stuff like that right now at this point in the hearing and way after the fact, that's going to be justification for this Frank's hearing being granted, because she just gave an example of how they're inserting new details at a later stage that may have been effective if they told the magistrate at the beginning. So he cautioned her, and he says, Here is concerning telling that. Where is that in the record currently? If you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. She just showcased why a Frank's hearing is needed. She'd once again entered new evidence in the courtroom right then and there that wasn't available in the records or given to the magistrate. Phone was in the area where the tower serviced the 112 residence. No bearing on the search warrant, just a matter of clarification of who did the work, but doesn't change the probable cause. She's talking about Dylanmortensen, 2 buckets. First judge was never informed that DM told law enforcement when shown a picture she didn't recognize the defendant. So that was a new fact we didn't hear, so that must have been said in the closed hearings, because I didn't know that she had been shown a lineup of Bryan and she didn't recognize him, so that's the first time I was hearing of it. So then the judge asks, what was the relevant statements of Dylanmortensen that were included in the affidavit that were included, in this PCA? Why was it important that the judge knew what DM said? He was like, is this for like identification? Like, what was this for? And I'm like, don't lead her. Let her answer this question. So then she says general description of person and residence, and it was consistent throughout all her interviews, but she says just before this that DM, based on the PCA, it was clear that she wouldn't have recognized Bryan Kohberger. So right before she makes that statement of like she's been consistent throughout her interviews and of like the description, she also said right before that she wouldn't have it's very clear that she wouldn't have recognized the defendant because he had something over his face. So it's like, which is it? That's 2 different things. So the judge was it also important to establish timeline? And then I didn't like that because it felt like a leading question, like he was leading her to an answer. And I didn't like that. Was he guiding her? Jennings said, it is. The timeline matches the vehicle's timeline. You could take out all of DM's statements. Since the defense is claiming some of the DM statements didn't make it into the PCA, she claims you can take them all out and you would still have enough for probable cause. The defense claims Dylanmortensen saying she's not sure anything she saw was real. A magistrate should know about it. Investigators knew what she saw was real and it wasn't a dream because they discovered the evidence the next morning. There weren't exculpatory statements that this didn't happen and we got it wrong. So she's saying that they knew that what she saw was real because the kids were dead the next morning. So regardless if she said that or not, they found the evidence. Vehicle ID. She's talking about the vehicle ID now. She said the magistrate was given a detail of the investigation in the vehicle. Stills were provided to a specialist that the vehicle was a Hyundai Elantra and that there was a discussion for the year. And I was like, yeah, I bet there was because you guys changed it. At the specialist's direction, he said the year range to focus on was 2011 to 2013, and Payne relied on his expertise to include in PCA. Emails attached as exhibits showcase that that's what happened. So they're saying they had a conversation about it via email, and that was included. 1125 Ridge Road footage, clear that can't be surveillance video even though it's 3 miles from crime scene, caught on video in 3 minutes right before we see the suspect video enter the area, appeared to be the amount of time to travel from crime scene. Surveillance right up the street would have had captured, and that's not true, and we submitted. When did you submit that? The judge asked. Jennings said it was submitted with my response, and this is exactly why we need a Frank's hearing. They have withheld so much, and it keeps coming out now, even though they've been asking for it for years now. Judge says, I was afraid you were going to say that. So he's catching her saying that she submitted this new information in her response for this Frank's hearing, that it wasn't in the record before that. And so he was like, oh, I'm a little concerned you were going to say that. So it seemed like he was kind of like, okay, Jennings, now you're not really proving your point, and you're giving me more fodder to grant them this hearing. She said, Special Agent confirmed Bates 15990 surveillance that was set up to capture motion would not have captured the corner that would have been captured. The defendant's speculation is no basis for a Frank's hearing. I was like, you just proved there needs to be a hearing twice now. She keeps saying things, and just because she keeps saying they're wrong doesn't mean that they are. Is it possible to tell from the affidavit? So the judge is asking this question. Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification from the PCA? Like, if you're reading the PCA, do you know exactly what cameras were referenced and relied upon for that PCA? Okay. And she says, no, it doesn't. Jennings, it states videos were reviewed and images turned over to a specialist, and that the specialist made the determination We didn't describe every image or clip we relied on, nor did we need to. She goes, nor did we need to. And she's so smug. It just makes me so annoyed. I would be annoyed if I was the judge, but that's just me. The Franks issue with the IGG, the fact that it was not included in the PCA is at the basis for a Franks hearing. Testimony. Law enforcement received tip and did a strategic not to include it and to create a PCA separately. Yes, to hide what they did, duh. And then IGG is only inculpatory, is what she said. Meaning, like, it makes him look guilty. And the non-reliance on the IGG info does not diminish probable cause, and the IGG was confirmed through the STR testing, and it wouldn't be exculpatory. She's talking about the dog barking now. She says 20 to 30 minutes, unclear how it's exculpatory, doesn't diminish probable cause. Their proffer is only the opinion of the evidence. It's exactly what she's doing, though. And she says to the judge, it doesn't give them the basis to grant a Franks hearing. If I was the judge, I would be so irritated by that statement. Her arrogance is annoying. You'll see it if you watch it. It's just appalling. The footprint outside DM's bedroom inclusion was misleading, consistent with DM's statements. She states that the defense argument where the shoe print should have been doesn't rise to the level of a Franks hearing. Their case doesn't hinge on the footprint, probable cause with or without this information. And then she talks about the grand jury subpoena. Now, they wanted to hear what the grand jury had heard, and they won't give it to them. The judge addressed the cell phone data, purposely erroneous to the time the phone was no longer reporting relates to the supposed position of travel. Jennings, I don't know that I completely wrap my head around the defendant's logic in this, but the judge retorts that I have to, so help me out. And I'm like, thank God. He was just put in her place. I understand, he says, I understand Anne's statement. He goes, I understand her statement and argument. I'm trying to understand your response. And I was like, oh, damn, he's smart with her. But so he has his moments where he can be really like, yeah. The information reported at the time was that the PCA was given. The information at the time was what the PCA was given, like that they had. And Payne, the judge asked, and she said, the information he was given, and the judge states, well, this goes back to my first question of imputed erroneous statements, meaning the statements that were given to Payne. How does that affect everything? And that's what he asked at the beginning. Did the cast specialist know there was a misinterpretation or erroneous support? The judge asked. She just states that the proffer given by defense does not provide enough evidence that false information was given, but she isn't providing the opposite either. So this is my part 5. I'm going to do a part 6. I'm hoping to finish this up soon. If you've been following me this far, I hope you're understanding what I'm saying and where I'm coming from. It was about 3 hours worth of information. So if you make sure you like and follow, or follow on YouTube, I will post all of these together and stitch them together in one video. If you have any questions, leave them below, and make sure you like and follow this video for more. So I'm hoping this is going to be my final part for my overview of January 23rd, specifically for Bryan Kohberger versus the state of Idaho hearing that happened regards to a Franks hearing. And I explained what that was, and all the way up until this point, if you go back and watch the previous 5 segments, hoping this will be my 6th and final. Right now, Ashley Jennings has gotten up to address the court on the things that the defense has put forward, arguments, etc. And she's now talking about the difference of the 7 minutes that Anne alluded to with regards to the footage of the car and how and the reporting of the phone to the network and how that can make a difference. And if this information was given to the judge, would they have still granted the warrant for Bryan's arrest? So when she talks about it, she just says, okay, like, so what? But that's a huge deal. Like, she goes, so what if there's a difference in 7 minutes? It's like, that's a huge deal. It's a big deal. She says it's not material. It is material if you look at where the phone was in that 7 minutes, the judge says. If it says it's going a different direction than your PCA says it was going, isn't that material? So obviously he sees something is wrong with this, that they're just shrugging it off, and he's like, no, you need to address this. I would say yes if it was reporting to a tower outside of Pullman, but it wasn't. What is she I don't even know what she was talking about there. I think she was stumped on his question and that he was putting her in a corner, backing her in a corner, and she like wasn't making any sense. Like, she's talking about a tower in Pullman. What are you talking about? She says this assumption suggests that the car can't change direction of travel. Jennings, that's exactly what it's suggesting, that his phone was going another direction, and she just proved that. So that was my notes, basically saying, duh. She starts to blabber, and not make any sense, talking about it's an hour before the murders and she doesn't follow the logic. If the car turned in another direction, it proves that he didn't go there. It proves that he didn't go there. That's exactly what it proves, Ashley. And we weren't talking about the car direction. We were talking about the cell phone location. She says to the judge, I'm not sure if that answers your question. And his answer, he says, well, that's your answer, so I have to just accept that, that's your answer. And she goes, which is a non-answer. She tried to play devil's advocate and say, "Oh, let's say that it's recklessly included and that the judges still had enough, and then that the judge still had enough before for probable cause." So she's like, "Let's say that the information given by Nick Balance or other FBI agents that was included was wrong. Okay, let's say it's wrong. She still had enough for probable cause." And it's like, how do you figure she's gonna have things that are gonna be questionable if? So anyway. I hope you guys are following this, but then she talked about the grand jury subpoenas. Defense wants to see them, but Jennings claims not the basis for the Franks hearing. No legal basis to support that idea. Nothing obtained that violates the defendant's rights. Not clear to state why the magistrate would need to know that. They won't let the defense see them, but why? Lack of connection. No bearing on probable cause determination. The investigators related on information known at the time, but Anne proved that they didn't reveal everything for the whole purpose of the Franks hearing, which is the whole purpose of it. She claims that Bryan Kohberger's car was still being reviewed and they didn't know if there was a connection. But you did know that there was other DNA in the home. So I'm pointing out the fact that they may not have known that there was a connection at the time, or there was no connection through his car or whatever at that moment when they got the warrant, but they did know about the DNA on the railing, at least that. I'm not sure when because they got that glove outside the home later, and so that might not have been known at the time, but the railing, they had to process that in the house, so they knew that at the very least. But that there was other DNA in the home and the latent print outside of DM's bedroom, the footprint, and that DM's statements were amiss. They were all over the place, so why wasn't that presented that way to the judge? She claims only a few warrants fell outside of that: Microsoft, Google, Apple, YouTube, TikTok, PayPal, and the vehicle and his belongings were taken 6 weeks after the crime. She's saying defense says it should not have been included, or should have been included, and she's saying there was enough outside of that to prove probable cause. Anne rebuts, and Anne's back up. She says, new police report, so Jennings had mentioned a police report that Anne hadn't seen yet, and she's like, whoa, I haven't seen that, judge, like, I haven't had a chance to review that, and the judge said it's not going to be included in my decision. So Anne starts talking about the grand jury subpoenas again, told no multiple times. Magistrate used to rely to give warrants, and they haven't been able to review them. Anne states that the state has a pattern of not giving information and saying, oh, but we didn't do anything wrong with it, but you can't see it to confirm that. Judge asked about the misstatement as relates to the Amazon warrant, and the FBI used the grand jury system and obtained this information outside of the warrant process, but for some reason we need to come get a warrant because nobody gets to review. She says she has them in other cases and doesn't understand why they are withheld here. She's talking about the grand jury information and why she can't see it. She says she has other cases where she has been able to review it, and she doesn't understand why they're not providing that. So the judge was stated the state said the information given was the result of a grand jury, was used and disclosed, and he asked her, what did they say that was not true, or what did they fail to disclose? And she says they failed to disclose the parameter around the grand jury subpoena. 7 minutes not disclosed that's intentional, not given to the judge to make a decision. She refers to the testimony given of the hours that took place, and a decision to keep certain things secret, and believes that they have delivered the intentional withholding of information from the magistrate. Credibility of DM, that information was relied on that after Bryan Kohberger was arrested, that this person has bushy eyebrows, so DM must be right. It's relied on with regards to the footprint. Anne claims it was one footprint at the edge of her door. Anne introduces a new piece of the puzzle that DM stated one of the victims ran downstairs and repeated this 4 times in the first interview. And that's not true because they were found in beds murdered upstairs. Statement withheld from the magistrate. 2 references to her not remembering, being intoxicated, don't know if it was a dream or if it's real. DM says someone was crying in the bathroom. The vehicle ID. What could the magistrate see? the way it's identified, you would think it would be caught on camera next to the house, and that's not the case. Experts said it's not identifiable. So she's saying the footage is fuzzy and that the judge wasn't made aware of that. They were thinking it's very clear and that they can see it and whatnot. The judge was, what was the evidence that law enforcement relied on? The Ridge Road footage to identify the vehicle? Question mark. They relied on the Ridge Road camera, and you can see in that, in the emails from Himmel and other law enforcement, they said they have Paradise Creek Road and say we finally got a good one, and it produced us the 125 Ridge Road footage and photograph. And that's the only one you can ID the vehicle where it is in motion. An original memorandum proceeds to show the judge, page 17. And then IGG doesn't identify a person, just a family group, but that was done behind the scenes and in the closet. Intentionality. Look at the entire picture of what happened. Law enforcement meeting and FBI, lots of things you have heard or withheld or super secret. Lots of meetings are happening on IGG, AT&T records. Partial picture was decided upon to get the warrants. Hidden and it's hidden so they can't check their work. So that is the final part of, and they stopped for the day on January 23rd, and so I still have to review January 24th, but I hope you guys enjoyed this review. I hope it made somewhat of a sense. I tried to take notes, copious of them, very quickly, so I'm trying to decipher as I'm reading them to you what they said, but this is definitely a lot shorter than the hearing itself. And if you have any questions or you find anything when you watch it yourself, it is on my YouTube channel available to you. You can watch it yourself if you have the time. I encourage you guys to do that, and we can have lively discussions. Please be kind. Make sure you follow, like, and comment. I appreciate all of you guys, and I will be back with January 24th soon. Bye for now.